Hi, my name is Danielle Munro, and today I will be presenting the case Elmslie and Others versus the Federal Commissioner of Taxation. I will be discussing the facts, the issues, reasoning, the judgment, and finally the implications for tax practitioners. Here you can see a small timeline of how the taxpayers came about. In 1967, a stockbroking business was commenced by Mr. Vowder as a sole trader. 6 months later, Mr. Elmslie became a partner in the business. It became known as Vowder, Elmslie and Company. Mr. Moore became a partner in Vowder, Elmslie and Company in 1974, and in 1980, Mr. Moyes became a partner in Vowder, Elmslie and Company also. So we have four taxpayers who are now all partners of Vowder, Elmslie and Company. They are John Harrison Vowder, Alan Rover Elmslie, Charles Frederick Moore, and Alan Richard Moyes. In May 1985, Jardine Fleming, an Australian subsidiary of Hong Kong Merchant Bank, offered to pay $400,000 for a one-half interest in the partnership. They offered to buy the remaining 50% when foreign investment laws permitted. The two taxpayers were Mr. Grubb and Mr. Smith. In June 1985, Vowder Elmslie acquired a $2 shelf company called Amalia Proprietary Limited. The four Vowder Elmslie partners, as well as Smith and Grubb, were appointed the directors. On the 25th of June, a general meeting was held where they resolved to change the name to Vowder Elmslie Jardine Fleming Limited, also known as VEJF. A document known as the Heads of Agreement, dated the 28th of June 1985, was signed by each of the taxpayers and a representative of JFA, and comprehensively set out the agreement terms of the sale. The transaction required the approval of the Foreign Investment Review Board, and on November 7th, the parties had not executed the formal agreement contemplated by the Heads of Agreement document. On the 17th of September, the lawyer forwarded to Mr. Moore the execution copies of three documents. One was a deed. The second document was styled Shareholders Agreement, and the final one was the Purchase Agreement. These were all dated the 12th of September 1985, but none were executed that day. On the 30th of August, Vowder Elmslie ceased trading, and then the following Monday, on September the 2nd, VEJF commenced trading from the same premises and using the same staff that had formerly worked for Vowder Elmslie. By the 2nd of September, VEJF was fully equipped to take over Vowder Elmslie's business operations and did so. On the 25th of October, the Commonwealth Treasury notified Mr. Moore of FIRB approval of the transactions. 3 days later, all the proposed shareholders applied to VEJF for an allotment of shares. Mr. Elmslie and Mr. Vowder each applied for 75,000 shares. Mr. Moore and Mr. Moyles, who each already had one share, applied for 74,999 shares, and JFA applied for 300,000 shares. A VEJF directors meeting was held on the 7th of November 1985. It was attended by Mr. Elmslie, Mr. Moore, Mr. Moyes, Mr. Grubb, and representatives of Law and Milne, and the solicitors acting for JFA. During the course of the 7th of November meeting, the directors resolved to allot shares in accordance with the applications dated the 28th of October. The shares were duly issued and a return of allotment shares was filed with the National Companies and Securities Commission. On the 1st of April 1987, the rule change permitting 100% non-member ownership came into force. It seems around that time the requirements under the Foreign Takeovers Act were relaxed, in such a manner as to permit a stockbroking business to be wholly owned by foreign interests. That cleared the way for JFA to acquire the applicant's VEJF shares as previously agreed. JFA decided to do so sooner than the date, December 90, specified in the shareholders' agreement. In July 1987, Mr. Elmslie and Mr. Vowder each sold their $75,000 shares in VEJF to JFA for $1,275,000, and on August 1987, Mr. Moore and Mr. Moyles each sold their shares, apparently for $1,822,475. The view of the Commissioner was that the capital gains derived by each applicant was assessable in the year of sale, that is, the financial year ending 30th of June 1988, and that the amount calculated by deducting the cost base from the sale price for each taxpayer. Here is a breakdown of the events. In late 1984, discussions commenced with JFA Company. In May 1985, JFA offered to purchase 50% interest and the other 50% later. In June 1985, the heads of agreement was signed. In July 1985, an application for Foreign Investment Review Board approval and company trading license. 30th of August 1985, Vowder Elmslie and Company ceased trade. And then on the 2nd of September 1985, Vowder Elmslie Jardine Fleming commenced trading. The issues. The primary question in the case is whether the shares allotted to each applicant after the 20th of September 1985, namely on the 7th of November 1985, were assets acquired by the applicants under a contract made before that date and thus excluded from capital gains tax under Part 3A of the Income Tax Assessment. The application of Part 3A asked the question, when were the shares acquired and what was the true market value on market day? The applicants contended that although the shares were allotted after the 20th of September, they were allotted under a contract made before that date, namely the Heads of Agreement document executed on the 28th of June and 3rd of July 1985. Accordingly, 3rd of July 1985 is the time of acquisition of the shares. Section 160L(1)(b) is not satisfied and there is no liability to capital gains tax. The Commissioner disagreed. They argue it is not correct to say that the shares were acquired under the Heads of Agreement. There was an argument over whether the Head of Agreement document had immediate contractual force. Here we have a quick overview of the legislative timeline. Prior to April 1984, stockbroking businesses must be 100% members of Sydney Stock Exchange. April 1984, the exchange rules altered, allowing members, non-members, and foreign interest. December 1984, foreign shareholding limits raised to 50%. A review was raised for April 1987. On the 20th of September 1985, capital gains tax was introduced into Australia. In July and August 1987, FATA relaxed business ownership of foreign interests. The question is, when was each applicant acquired his 1/8 interest in the share capital of VEJF? An allotment of shares is, in law, an acceptance by an allotting company of the offer to take shares made to it by the application for allotment. In each case, a contract came into existence on the 7th of November 1985 when the Board of Directors resolved to allot shares in accordance with applications dated the 28th of October 1985. In each case, this was the contract under which the shares were acquired. The Commissioner referred back to the case Chan and Creasden Proprietary Chan versus Creasem Proprietary Limited, where the lease was not registered and was therefore ineffectual to pass an estate or interest in the land. In Chan, the question was whether guarantors were liable to make payments to a leaseor pursuant to a clause in a lease document whereby they agreed to guarantee performance of the lessee's obligation. As the lessee had gone into possession of the land, it was liable to pay rent, but the High Court held this liability was not an obligation to be performed under this lease. It's important to note that the lessee went into possession of the land only because of the execution of the lease. The claim against the guarantors was for rental accrued during the period of possession, but the lease was not the immediate source of liability for rent, so the guarantee did not apply. It was not enough that, absent the lease document, there never would have been a liability for rent. In the same way, it may be considered that the arrangement between the applicants and JFA, evidenced in the Heads of Agreement document, was the background against which the applicants made their applications for allotment of shares on the 28th of October, and the shares were allotted on the 7th of November. Nonetheless, the shares were allotted under the contract then made, not the earlier arrangement. What was the true market value on allotment day? Section 160ZH says, in determining the cost base, the index cost base, or the reduced cost base to the taxpayer of an asset, if C. the consideration paid or given by the taxpayer in respect of the acquisition would, but for this paragraph, be greater or less than the market value of the asset at the time of the acquisition, and the taxpayer and the person from whom the taxpayer acquired the asset were not dealing with each other at arm's length in connect with the asset, an amount equal to market value at the time of acquisition. During the court hearing, two valuers gave their reports to the Commissioner about what they believed the true market value was of the shares on allotment day, the 7th of November. All the facts were taken into account from each report, and a conclusion was made that the true market value on allotment day of the shares were $3.60 per share. The Federal Court determined that the shares were indeed allotted on the 7th of November 1985, which was after the specified date of the 20th of September 1985. Therefore, they were subject to capital gains tax. It was also determined that the applicants were not dealing at arm's length. The value on the 7th of November 1985 of a parcel of 75,000 shares in VEJF was $270,000, which equals to $3.60 per share. In the result, each applicant fails on his primary submission that the capital gain derived from the sale of his VEJF shares was not subject to tax, but each applicant succeeds in his challenge to the cost base adopted by the Commissioner. In each case, the amended assessment should be set aside and the matter remitted to the Commissioner for reassessment on the basis that the cost base of the subject shares at November 7th, 1985 was an amount equal to $3.60 per share. Implications for the tax practitioners. The nature of the contract. The contract that changed the ownership of an asset is the only contract that determines the acquisition of the shares. And the character of the cost base used to determine the net capital gain or loss is the true market value at the time of acquisition that must be determined if parties are not dealing at arm's length at time of acquisition.